We have today Massimo Leone as a keynote. Thank you very much, Massimo, for being together with us. Massimo Leone is professor of semiotics, cultural semiotics, and visual semiotics at the Department of Philosophy and Educational Science at Torino University. His field of research is very, very wild and stimulating: semiotic and religious, visual semiotics, semiotic of law. And he just told me that he came back from Tallinn, Hamburg, and so it's a very it's a very busy person. So without further loss of time, I give you the word.
Thank you very much. Can you hear me well? Maybe. Yeah. Is that okay? Yeah. Okay. So thank you very much, especially Andrea, for this wonderful event, but also Sarah, Richard, all those who collaborated in engineering this collaboration. I think this is not working. Let's see if... Okay, well, they're going to use this, probably more reliable. So in ancient Rome, an orator didn't just take control of objects, he took control of words. The act of usurpare wasn't limited to seizing property. It extended to reshaping language itself. In Latin, usurpare could mean to take something by frequent use, whether through action or speech. So in the Roman worldview, usurpation wasn't just about ownership of things, but also about reworking the meaning of words. It blurred the line between material possession and symbolic power, merging objects and language into one intricate web of control and meaning. This connection speaks to a fundamental human principle. Our relationship with objects, tools, land, possessions has always been tied to our relationship with meaning. To control an object is to redefine its purpose, to assign it new significance. As technology evolves, so does this process. Take the knot. The knot will be the protagonist of this talk. Take the knot, for example, seemingly simple, yet loaded with meaning. A knot isn't just a material thing, it's a deliberate cultural act. While nature might coil a vine by chance, humans knot with intention, transforming a physical action into a sign of control. This act, much like usurpation, turns nature into culture. As we shape these objects, we simultaneously shape their meaning, moving from merely observing the natural world to actively transforming it. The knot is more than just a tool, it's a marker of human agency, deeply tied to one of the defining features of Homo sapiens, the opposable thumb. Try to knot something without your thumbs. It's going to be very difficult. Without this anatomical advantage, the act of tying a knot would be nearly impossible. In this way, the knot stands as a symbol of the evolutionary leap that allowed humans to manipulate the physical world in complex ways. It also acts as a bridge between language and material culture. As I've argued in other contexts, producing meaning is akin to knotting, where fibers of language are woven into coherent expressions, just as threads are woven into knots. The knot symbolizes both the strength of memory and union and the human incapacity to undo what culture has created. The symbolism makes knots a recurring object in myth and iconography, portraying the superhuman ability either to bind nature or to untie what has been bound. In Christian imagery, after all, I'm the director of the Center for Religious Studies, the knot appears frequently both in practical and symbolic contexts. Anthropologist Cyrus Lawrence Day, in his study Quipus and Witches' Knots, published in 1967, categorizes knots into three types: mnemonic, magical, and practical. Long before the invention of writing, cultures such as the Incas used knots in their quipus to record genealogies and calculate numerical and astrological data. In Mexico, Carl Lumholtz, in Unknown Mexico, published in 1902, recounts how Huicol women tied knots in palm leaf cords to confess their illicit relationships before sacred fires while their men were away on pilgrimage. These knots, representing past lovers, were thrown into the flames after each confession, their burning signifying purification. Similarly, Christian prayer beads or rosaries serve as mnemonic devices. Ethan Wilkins, in The Rose Garden Game, published in 1969, describes how rosaries allow worshippers to keep count of their prayers using knots or beads, paralleling physical action with spiritual practice. Each knot in a rosary is not just a marker, but a locus of spiritual focus, guiding the faithful through their devotions as they move along the string. In these varied cultures, from the sacred fires of Mexico to the hallowed halls of European churches, knots become more than mere objects. They are tools of memory, ritual, and connection to the divine. The knot, an artificial object imposed on the natural configuration of fibers through human intentionality, becomes a potent meaning-making device that serves two intertwined purposes: counting and recounting, storytelling and calculation. These operations are not separate in the early stages of many human civilizations, but stem from the same fundamental negentropic intent to project order onto what appears to be chaos. The Peruvian quipu is both a mnemonic tool and a narrative system, transforming knots into an ancient form of writing. Garcilaso de la Vega, in his Comentarios Reales de los Incas, 1609, and Felipe Guamán Poma de Ayala in La Nueva Crónica y Buen Gobierno, 1615, describe how the quipu functioned as a means of keeping records of genealogies, taxes, and even astronomical data. From a physicist's perspective, the notion of objects as negentropic is compelling. Entropy, as we know, is a measure of disorder or randomness within a system, and the natural tendency of the universe is towards increasing entropy. However, objects like knots or more broadly human-made artifacts serve as pockets of negentropy, localized zones where complexity is reduced and order is imposed. In the case of the quipu, we see this clearly. A chaotic tangle of events, memories, or data is systematically organized into a structured symbolic format. This reduction of complexity is not merely a physical act, but an intellectual one, where knots become compact and manipulable entities that allow humans to manage the overwhelming complexity of their environment. The first knots may have been made from hair, as suggested by the intricate braids found on prehistoric statues like the Venus of Wilderdorf, dated to around 25,000 years ago. These early representations likely reflect an emerging human capacity to manipulate materials, transforming simple strands of hair into intentional configurations, symbolizing control over one's body and appearance. With time, humans began to apply this practice to natural fibers, tying knots for practical purposes like securing objects, and eventually leading to the development of weaving. Weaving can be seen as a systematization of knotting, moving from the one-dimensional structure of a single knot to the two-dimensional complexity of textiles. This shift from knotting to weaving marked a significant evolution in human history, allowing for the creation of more sophisticated tools, clothing, and even social markers. I'm trying everything I can. Okay. However, the most dramatic shift in the human relationship with knots came with the Industrial Revolution, which mechanized both knotting and weaving processes. The invention of mechanical looms in the 18th century, such as the Flying Shuttle, 1733, by John Kay, and later the Spinning Jenny, 1764, by James Hargreaves, revolutionized textile production. These machines could rapidly produce fabrics by intertwining threads in patterns far more complex than any manual technique could achieve. The jacquard loom, introduced by Joseph-Marie Jacquard in 1804, went even farther, automating intricate weaving patterns through a punch card system that foreshadowed modern computing. This transformation did not just speed up production, it fundamentally altered the role of knots and weaving in human society, shifting from individual craftsmanship to mass industrial output. In this sense, the mechanization of weaving also transformed the knot from a symbol of individual agency to one of technological abstraction. The loom itself became an negentropic device, reducing the complexity of human labor into predictable, repeatable processes, while simultaneously producing highly complex woven patterns. The knot's transformation in this industrial context represents a broad revolution in how humans interact with objects, from direct manipulation to mediated machine-assisted interaction. With the transition from the textile loom to the computational loom, the knot underwent a profound transformation. No longer limited to a three-dimensional artifact that binds the fibers together, the knot became integrated into a fabric that transcends physical space and begins to interact with time itself. In computational fabrics, such as those designed by early pioneers like Charles Babbage with his analytical engine, or later the von Neumann architecture, knots evolve into what we now understand as nodes in complex networks of information. Here, they cease to be static spatial configurations and become dynamic temporal entities, negentropic not only in their capacity to order material, but also in their ability to structure time. In the case of memory in computational systems, the knot metaphor is especially relevant. Memory knots within computational fabrics store and retrieve information not merely across physical dimensions, but across temporal sequences as well. In modern computers, the memory functions as a series of knots that both recall and manipulate sequences of events, allowing for the simultaneous organization of past data and the prediction of future actions. This idea can be further enriched by considering topological knot theory, which studies the properties of knots that remain unchanged through deformation, stretching, or twisting. In topology, a knot is not defined by its appearance, but by its underlying structure, which persists through transformations. Pioneers like Kurt Reidemeister laid foundational work with his Reidemaster moves, a set of operations that allow us to manipulate knots diagrammatically without changing their fundamental topological properties. The Jones polynomial, introduced by Vaughan Jones in 1984, further exemplifies the knot's complexity by assigning a polynomial to a knot, capturing its essential characteristics. Similarly, in human cognition and semiotics, ideas undergo a process akin to these mathematical operations. They can be twisted, simplified, or recontextualized, but certain core elements resist change, much like an irreducible knot. Whether dealing with physical knots in textiles or conceptual knots in culture, the principles of manipulation remain anchored by topological invariance. Thus, the evolution from physical knots to computational knots mirrors this topological complexity. Just as mathematicians study how knots resist entropy through their invariance, humans have used knots, both literal and metaphorical, to impose order on reality. In computational fabrics, memory knots serve as repositories of both space and time, maintaining the integrity of data across different contexts, much like topological knots preserve their essential structure through transformation. From the earliest braiding of air to the knotting of fibers and weaving of textiles, humans have always sought to impose order on nature through knotting. Each knot tied in the past, whether in the strands of hair, on the Venus figurines, or in the fibers of ancient textiles, served both the practical and symbolic purposes, representing the human capacity to bind and control materiality. This evolution reaches a new level in the development of large language models, such as the transformer-based architectures that power modern AI systems like GPT-4. These models are built on complex multi-dimensional networks of neural connections where each layer represents a different abstraction of language. The architecture of such models involves attention mechanisms which allow the system to weigh the importance of different words in a sequence, effectively creating nodes of contextual relationships within vast datasets. The self-attention mechanism in particular is akin to a computational knot where each token is interconnected with every other token in the input sequence, generating a dense web of meaning that spans across multiple dimensions. In AI, the knots formed are not just representations of words, but embeddings, multidimensional vectors that encode semantic relationships. These embeddings, trained on terabytes of data, map complex relationships between language elements that are far beyond human intuition. In this sense, the knots in AI systems are computational knots representing the entangled relationships of context, syntax, and semantics. Unraveling these interconnections to trace a single thread of meaning becomes nearly impossible, as each knot holds the cumulative weight of countless interwoven layers of training data. Techniques like backpropagation and gradient descent function as optimization methods to adjust these weights, fine-tuning the knots, but they do not simplify them in the traditional sense. Rather, they deepen their complexity, creating multi-dimensional knots within the model's vast parameter space. The knots formed in large language models are not easily unknotted. They represent a web of intertwined meanings and connections that we are only beginning to understand. The complexity of these models creates a new kind of maze, one where the relationships between data points are as convoluted and intricate as the most complex topological knots. And as with any maze, you know that amazement derives from maze. It's a form of labyrinth where, the sense of orientation is lost. While the pathways are interconnected, untying them to reveal their original simplicity becomes nearly impossible. So the leap from physical knotting to computational knotting marks a new chapter in the human relationship with complexity. We are now navigating mazes of meaning where each new knot, whether in language, data, or computation, adds another layer to the fabric of reality. The challenge and perhaps the amazement lies in our evolving capacity to create knots that bind not only material but time, information, and meaning in ways that inspire awe and reflection on our place in this ever-complexifying maze of existence. Up until now, humanity's efforts at knotting, whether in braiding, weaving, or computational structures, have been negentropic mechanisms, meaning they aimed at reducing complexity by creating ordered configurations from the chaotic substrate of nature. But crucially, these knots did not alter the fundamental structure of nature itself. Rather, they transformed natural elements into representations of something else. When we knot fibers or weave textiles, we impose external order without actually affecting the inner molecular structure of the fibers themselves. Even as we move into the realm of computational knotting, the complex architectures of data and information remain representational. They are abstracted models of reality, not reality itself. However, we are now reaching a different threshold in the history of knotting, where the lines between representation and reality blur. Today, quantum entanglement introduces a radically new form of knotting, one that does not merely represent reality, but has the potential to reshape it at its most fundamental level. In quantum entanglement, we are no longer dealing with spatial knots that can be visualized or untied in conventional ways. Instead, we are engaging with a kind of knotting that operates beyond the confines of classical dimensions. Entangled particles are not connected by physical cores, but by an invisible, instantaneous linkage that defies our conventional understanding of space and time. The phenomenon of quantum entanglement, as first proposed by, of course, this is going to be very trivial for the physicists, I apologize, as first proposed by Einstein, Podolsky, and Rosen in 1935, the EPR paradox, and later experimentally confirmed by the likes of John Bell and Alan Aspect, suggests that two or more particles can become intertwined in such a way that the state of one particle is instantaneously correlated with the state of another, no matter the distance between them. This is knotting at a level previously unimaginable, a multi-dimensional entanglement where the particles' fates are bound together and measuring one instantly affects the other, transcending the conventional limitations of space-time. Unlike classical knots, which are constrained to operate within the dimensions we understand, quantum entanglement fundamentally challenges the very notion of dimensionality and knotting itself. It seems to create a relationship that is not bound by the physical space we know, but operates on a deeper, non-local level. From a philosophical perspective, the entanglement of quantum particles marks a leap from representation to intervention. We are no longer merely knotting to model nature or to represent complex systems. We are beginning to understand how to knot reality itself. The entangled particles act not merely as symbols of connectedness, but as evidence of an underlying order in the universe that we are only beginning to grasp. Quantum entanglement pushes the human history of knotting into a realm where dimensions collapse and where the act of knotting can potentially alter the very fabric of nature itself. In this new phase of knotting, we move beyond the tangible fibers of prehistory, beyond the two-dimensional weaves of textiles, beyond the three-dimensional knots of everyday experience in fabric, and even beyond the four-dimensional knots of computational systems. Quantum entanglement introduces us to a form of knotting that not only transcends traditional dimensions, but perhaps questions the very nature of what it means to knot. As we bring this exploration of knotting to a close, it is crucial to engage with another vital perspective in this room, the jurists, which are very knotted usually. Throughout history, humans have not only imposed a cultural and negentropic order onto nature through the act of knotting, but we have also sought to impose a normative order onto these human-made configurations. When we knot, we create something that is no longer governed by the laws of nature alone. It becomes a cultural artifact, an entity that requires human governance. Just as we knot fibers or weave textiles to resist entropy, we have sought to bind these creations with laws and norms that govern their use and meaning. Consider, for example, the rosary in Christian tradition, a tool for prayer that is itself a series of knots. The rosary is not merely a collection of beads and strings, but a deeply normative object. Its use is governed by strict religious rules, how it should be prayed, in what order, in what context. These rules were not laid out by nature, but by religious authority, casting a normative framework around a simple yet powerful series of knots that serve as both mnemonic devices and tools for spiritual practice. This interplay between knots and law extends far beyond the religious realm. The Industrial Revolution brought with it a host of new inventions related to knotting and weaving, many of which were subject to copyright and patent laws. The jacquard loom, for instance, was not only a mechanical marvel, but also a legally protected invention, one whose knotting mechanism transformed textile production and became the subject of intellectual property rights. These legal protections were essential in governing who could use, reproduce, or modify such technological advancements, illustrating how humans have always sought to regulate knotting as both a physical and intellectual endeavor. Today, as we move into the era of computational knotting and quantum entanglement, the legal challenges grow even more complex. We now face the task of regulating not just physical knots, but the abstract multi-dimensional knotting of information in AI and quantum systems. Large language models like GPT-4, for instance, create complex webs of connections, knots of data, meaning, and context that raise profound legal questions. Who owns the outputs generated by these models? How should these computational knots be regulated, especially when they operate beyond the understanding of any single human mind? And as we delve into quantum entanglement, where particles are bound in ways that defy classical physics, how do we create legal frameworks that address the manipulation of reality at this fundamental level? We are witnessing the emergence of knots that challenge not only our scientific understanding, but also our legal systems, demanding new regulations that can keep pace with these unprecedented developments. From the rosary to the jacquard loom, from intellectual property law to the cutting-edge debates around AI and quantum computing, the history of nothing is also a history of human attempts to govern the negentropic imposition of cultural order on nature. As we conclude, we return to the core idea that nothing, this quintessentially human act of imposing cultural patterns on nature, has now entered a new and unprecedented phase. In the realm of AI and quantum entanglement, the knots that we create are no longer merely objects that we control or use to represent reality. Instead, they have the potential to become agentive, even sentient, interacting with us in a ways that challenge our understanding of the world and our position within it. We stand on the precipice of a future where the knots we tie in these advanced systems may outgrow their original purposes, becoming entities that operate beyond our comprehension or control. This scenario brings to mind the rebellion of the objects imagined by Vladimir Mayakovsky, a poetic vision where human-made objects revolt against their creators. What was once metaphorical now seems increasingly plausible as we venture into the labyrinth or the maze of AI and quantum systems. These multidimensional knots, whose complexity far surpasses anything in human history, may not just resist untying, they might reshape themselves, act autonomously, and bind us in unforeseen ways. We risk being knotted by our own indissoluble creations, entangled in the very webs of meaning and reality we have worked so hard to control. This raises profound questions. Will these hypercomplex Gordian knots humble us, forcing us to reconsider our role in the universe? Shall we realize that our attempts to impose order on nature are inherently limited, that we are but one thread in a much larger fabric of reality? Or shall we, in Nietzschean fashion, embrace the idea of the Übermensch, believing ourselves capable of not only creating but mastering these new agentive knots, finding ways to cut through them like Alexander the Great with the original Gordian knot? The answer to these questions may lie in the very process we have engaged in yesterday and today, knotting our interdisciplinary thoughts together. Just as knots are the product of multiple threads, our understanding of the future of AI, quantum entanglement, and the law will only be as strong as the interdisciplinary fabric we weave. Philosophy, physics, technology, and law, even religious studies, must come together to address the challenges posed by this new era of knotting. Only by thinking together across disciplines can we begin to entangle the complexities of the hyper-complex knots we are creating, and perhaps prevent the rebellion of the objects from becoming more than a poetic metaphor. And now, thank you.
Thank you so much, Massimo, for this great presentation. I don't know whether we would like to give word to the public for now, or shall we do it at the end? At the end, okay. Okay, so thank you very much.
Thank you very much.
Thank you so much, Massimo. So we have the three panelists, Ugo Malvagna, Andrea Rossaro, and Giorgia Bincoletto. So we will start with Ugo Malvagna, who is Ugo Malvagna is a jurist, is professor of law and finance at Trento University, and his main topic of research is our banking law and law and finance. So Ugo, you have the floor.
Yeah, thank you, Elena. Thank you again, Andrea, for organizing this. Okay, so my presentation is about property rights and the blockchain, digital assets as ownership, question mark. So I I have to say that I am still building up my thesis and my analysis as well. As some of you know, I had begun a year and something ago to study these things. We have also been together to Rome, but then my second son was born and my life just went to pieces. So I've tried to take advantage. No, I'm joking. I have mainly focused during the last year on digital securities as a species of digital assets, which are a bit more technical, and also on smart contracts and algorithmic agreements. Now with some colleagues, we are out with a paper published by the Bank of Italy on smart contracts in the financial system. So that was my focus on over the last year. So I have tried to take advantage of this friendly occasion to try to start gathering again some thoughts. Also in light of some recent developments in the legal area in terms of lawmaking. And I make a reference to a model law, a draft model law issued by Unidroit on digital assets, on a bill proposal by the UK Law Commission on digital assets, and on some interesting provision of the German commercial code on digital securities. So based on all the foregoing, I'm not sure I will be able to make myself clear, especially to non-lawyers, but I will try hard. So my main point here is whether assets that are originated and represented on a blockchain, which I will refer to as digital assets, are capable of being the subject of proprietary entitlements in the legal sense of it. You know that lawyers, at least European lawyers, love a lot to rely on legal definitions as the base for the analysis. We do not have one here. I mean, at least we do not have in a hard positive law. What we have is the market in crypto asset regulations, at least at the European level, which is a recent regulation that addressed crypto assets, digital assets, more from a public law regulatory perspective and market regulation, rather than on private law, the private law status of digital assets. But there are some interesting definitions which are useful also to my purposes. There are basically 5 definitions. That is, what is the distributed ledger technology for the law? It's a technology that enables the operation and use of distributed ledgers, where a distributed ledger means an information repository that keeps records of transactions and that is shared across and synchronized between a set of DLT network nodes, but probably I should say knots, using a consensus. I really prefer the term knots to nodes, using a consensus mechanism, where the consensus mechanism means the rules and procedures by which an agreement is reached. And the DLT network node means a device or process that is part of a network and that holds a complete or partial replica of records of all transactions on a distributed ledger. So eventually, a crypto asset means a digital representation of a value or of a right that is able to be transferred and stored electronically using distributed ledger technology or similar technology. So the existing law uses this term crypto asset. We do not like to call it crypto assets anymore because it sounds really bad. It seems like there is some scam behind it. So the current expression widely accepted is digital assets. So basically we have a thing, a representation of something, or the storage of some information that is, after all, created by humans. And by the way, what I can tell you now is that the mechanics and interactions of such creation, such collective creation, is probably the most peculiar and interesting feature from a legal perspective. So in front of this, the question is, should the law treat these things and protect these things as ownership, or these are just obligation rights that some entities interacting through the network might or might not have vis-a-vis each other. So in order to address that question from a positive legal perspective, we need to understand what is a thing, or to be better said, a good for the purposes of the law, which is quite interesting, because the notion of good is actually defined in mysterious ways, in my opinion, which pretty much remained the same over at least over the last 2 centuries, and did not evolve, at least from a hard law perspective, not in terms of its interpretation. So in the Italian Civil Code, there is, which was enacted in 1942, there is quite an oracular definition that says, goods are things that are capable of being subjects of rights. The BGB, the German Civil Code, at paragraph 90, whose title is Begriff der Sache, so the concept of things, Sachen im Sinne des Gesetzes sind nur körperliche Gegenstände. So thing in the legal sense are only objects that whose feature is corporality. And the BGB was enacted in 1896. It is also very interesting, the Austrian civil code, the ABGB, definition of goods, the ABGB enacted in 1811, that basically says that alles, was von der Person unterschieden ist, so that everything which is distinct from the person, und zum Gebrauche den Menschen dient, and that serves the use of person, wird im rechtlichen Sinne ein Zeige genannt. So is by law, by the purposes of law, a thing. So we have these 2 features. So its detachment from the human, and its German scholars call it Beherrschbarkeit, meaning the ability to be controlled or exploited. And what about the French? We don't care about the French. We don't. No, we do not. No, the fact is that there is no definition of. I mean, they use in the civil code, in the 1804 civil code, there is no definition of. They have not defined it. They just, I mean, the opening provision of the livre deuxième, that is the one on things, just says tous les biens sont meubles ou immeubles, and that is it. Actually, in 2015, a new provision, a new introductory provision was added that says les animaux sont des êtres vivants doués de sensibilité. Sous réserve des lois qui les protègent, les animaux sont soumis au régime des biens. Donc, then the animals are, for some purposes, things, and for some purposes are not, not persons. I mean, not things. Let's say, let's put it this way. So, but there is no actual definition of what bien means. With reference to English law, well, as you know, English law, the English legal system being a common law system, doesn't have a statutory definition of. I mean, until now, it will probably have a definition in a few months, because there is a bill that is being passed. But basically, case law has developed some guidance in order to understand what is a good for the purposes of the law, and for enabling the application of remedies intended to protect proprietary entitlements. Basically, they're very much factual and economic based. So it needs to be definable, identifiable by third parties, capable in its nature of assumption by third parties, with some degree of permanence or stability, then it needs to be featured by excludability, rivalrousness, separability, and value. So these are the 6 criteria. And it is commonly taken that information is not property. And then there are 2 main categorizations of property under British law, that is things in possession, that are basically the analogous concept to our property in the strict sense, and things in action, which is basically our obligation rights that under our system are not things, but are something different. So try to find the common elements among these different definitions. What we may say is that based on the current legal landscape as developed over the last 200 to 300 years, in order to have a thing, or to be better said, a good for the purposes of the law, something that can be the object or the subject of ownership, it needs to be detached from the human, being able to be appropriated by persons and to benefit and be useful to them, and to be appropriated in an exclusive way, so meaning that the so-called jus excludendi remains the pillar stone of property rights. So the legal protection against any interference with the enjoyment of that asset, and only for the Germans being this thing being physical or material in the physical sense. And I would also add a last requirement, that is not being an obligation, so not being a right in personam, the right to obtain a certain behavior from another, to obtain cooperation by another, one or more persons. Accredited, yeah. Yeah, so the idea is that under the law, I mean, under the legal doctrines, things, I mean, you can own something that you can exploit without the need of someone else cooperating with you in order to obtain that benefit from the thing. So based on that, are these features met in respect of digital assets? Well, in order to approach this question, I think it is useful to analyze the legal status of things in the Web 2.0 space. So the current existing web model, so proprietary, centralized, so as you may think, I don't know, any two-sided market as Instagram or X or that kind of platform. So and also Web 1.0, so classic email, electronic communication. So let's think about money. Money not in the meaning of coins or banknotes, but in the sense of commercial bank money, so money on a bank account. So money, it's not even a thing, is basically a liability on a bilateral basis. So it doesn't have the features of being a thing, for being a thing. It is not protected through remedies that are intended to protect proprietary entitlements, but rather than the ones that are intended to protect claims, credits. Or let's think about securities. They are property to some extent, so a bond or a stock, but basically they are just a set of contractual rights wrapped into either a piece of paper or into a book entry when they are dematerialized. But this book entry basically is documented on a centralized ledger that is operated and maintained by either a public authority or by a private entity that makes, that performs public function in an objective sense, meaning is required to provide public faith to that, but it has the power to destroy that reality unilaterally, because the data infrastructure is under the full control of that authority. In the Web 3.0, I mean, the very reason for existence of the Web 3.0 is that there should be no central authority. So there is no entity whose behavior alone is able to tamper data in the distributed ledger or to modify the status of the distributed ledger if the conditions provided for by the protocol and by any smart contract that might be built on it are met. So basically, this enables a so-called trustless environment where people can interact without having an authority, a public or private authority that has a fiduciary role, because the rules are embedded in the very way this protocol functions. So I guess that my point is that Web 3.0 is virtual reality. So it is at the same time virtual and real, because even if it is not physical, it is still real, meaning that it is not just an electronic record that can be unilaterally erased by the entity in charge of maintaining that record, but it, let's say, it exists regardless of the observer or interested party. Is perceived by all observers as having the same status at the same moment, and also it can be changed only according to, let's say, objective rules, and this change is immediately synchronized over all the nodes of the network. So in this sense, it enables that unrelated entities interact with each other as they interact in the physical space. So I mean, I was very surprised that this, I mean, I feel that this resembles a lot what was said before with respect to quantum computing, when Professor Leone said that quantum computing introduces the ability to manipulate reality at the fundamental level, blurring the lines between representation and actuality. And I feel that also the Web3 area can be embedded in this concept to some extent. So of course, this requires some sort of evolution or adaptation of legal concepts. And very interestingly, UNIDROIT, which is basically a supranational institution that is in charge of fostering private law evolution and harmonization, drafted a model law on digital assets, tried to develop a concept intended to describe this immediate possession of digital asset, this idea of these assets existing and being able to be appropriated and being transferred without the need of the cooperation of anyone else, or at least without the need of the need of an intermediary in the traditional sense. And this was basically done by this new concept that is, let's say, the parallel of possession in the digital space, and in this UNIDROIT draft model is called control. So it says in the recitals, it said that while being akin to the concept of possession as used in certain civil law jurisdictions, control as used in these principles must not be understood to be identical to such possession. Where in civil law jurisdictions, a possessor may hold an asset through another person, under these principles, a person cannot control a digital asset through another person unless the criteria of Principle 6 are met. Principle 6, definition of control, says that a person has control of a digital asset if the digital asset or the relevant protocol or system confers on that person the exclusive ability to prevent others from obtaining substantially all of the benefits from the digital asset. That is the jus excludendi. The ability to obtain substantially all the benefit from the digital asset, and this is the appropriation feature, and the exclusive ability to transfer the abilities in subparagraph A1 and A2 above to another person. So the transferability, the power to dispose of that asset. And um, interestingly, in the comment to that principle, the commission says that the exclusive ability requirements in principle 6.1a of the principles recognize that the ability to exclude is an inherent aspect of proprietary rights. This requirement contemplates that control assumes a role that is the functional equivalent to that of possession of movables. However, possession in this context is a purely factual matter and not a legal concept. Moreover, because a digital asset is intangible, this functional equivalence to possession involves only the dominion and power over a digital asset, but does not involve the physical situs dimension applicable to possession of movables. So this is a very interesting attempt to evolve traditional legal concepts to adapt them to digital asset considered as personal property. So this being noted, I would like to conclude my speech with 2 points. The first one is the one of the feature of direct control and immediate fruition of digital assets that, as I said before, according to established legal doctrines, is a key element of ownership. So the question here is, who maintains the network on which each digital asset relies on? We also discussed this yesterday over dinner with some of you. So basically, there is an incentive mechanism based on which validators confer their computational power or help to some extent provide their work to maintain this distributed network in order, and basically they are rewarded through native tokens of the platform themselves, which on their turn are able to be sold and in any case exchanged in purchasing services of goods. So they have a value similar to the one of money. So this means that if the network externalities go down because people do not use the network anymore, there are no incentives to maintain the network so that the value of those assets will be destroyed. In other terms, in the digital asset world, we need cooperation from other entities in order to be able to continue benefiting and or disposing of the asset. So this may be an obstacle from a theoretical perspective to qualifying these as assets in the proper sense, because they would not be capable of direct and immediate fruition. But there are two objections to counter objection to this. The first point is that the cooperation required is not vis-a-vis one or more specific persons, but is from the community in an anonymous sense. So this implies that there can be no obligation right because there is no debtor, the identifiable debtor. And in any case, this interest is not vested in an obligation. So there are no platform providers that have the responsibility also from a contractual perspective to maintain that platform because it is decentralized. The other point is that also in respect of physical property, we are beginning to understand that in order to maintain the use value and the exchange value of assets, we need some sort of cooperation by the broader community. So let's think about, I don't know, a certain neighborhood becoming unsafe or disconnected in terms of means of transportation, how this affects the use value and the exchange value of that asset. Or in a broader scale, let's think about pollution and to the environment. Second and last point is that the programmable nature of such reality implies a shift in terms of how we consider the content of property. The power to enjoy a physical asset is given in nature. So what you can do with it, you can split it, you can merge it into something else or attach it to something else. And the law just protects this. Here, these powers, in terms of what you can actually do with those assets, needs to be designed and built into the system. Therefore, I believe that it's fair to say that in spite of appearances, the issues relating to how digital assets will be shaped and legally construed are quite not a matter of technology. Blockchain is basically a tool that may enable to build something sensible on it, but eventually it needs a design for its governance and for how proprietary entitlements are shaped and protected. And this will be a social construct rather than a merely technological one. Thank you.
Thank you. Thank you very much, Ugo. And we will have time for discussion later on. Now I give the floor to Andrea Rossato, a comparative law scholar at the Department of Psychology and Cognitive Sciences of the University of Trento. His main topic of research are law and economics, psychology, and digital tech. So Andrea, you have 20 minutes.
Yes,
I
thank you.
was so involved in listening to Massimo and Ugo that I forgot to be the chair.
I'm
So keep
using
it.
a stopwatch, so I should be
Okay.
able to.
Yeah.
Okay. Okay, so thank you very much for the invitation. It's a real pleasure to be back in the place where everything started, at least for me. So, but I need to start with an apology because I decided to change the title of my talk because I was listening to Andrea. Andrea said, "Well." Andrea said that you're going to talk during the virtuality session. And so please use virtuality in your title. And I did so, but when I started writing my slides, I found out that what intellectual property, artificial intelligence, and computational power have in common is not being virtual, but being artificial, which is different, but interesting, I think. So I have to control. There are 14 slides, but many of them are just blank pages, so don't be worried about that. I needed to take a historical perspective in order, to get to my conclusions. So I'm sorry about that because I believe that this is a story you're familiar with. So it will be a sort of a repetition. Still, the origins of what we used to call cyberspace, and I like to still use that word, the origins of cyberspace are quite interesting because originally cyberspace was populated by what I write, members of knowledge sharing communities. Those members of knowledge sharing communities were the people who were actually building that new infrastructure. So when graphical user interfaces, affordable personal computing devices, and internet connections made it possible for a broader set of population to start populating the digital space, the cyberspace. Well, there was a deep demographic change which led to, well, a cultural clash. And we can find tracks of that in, I didn't start my stopwatch. In some documents, there was something called netiquette, okay? And that was a request for comments. It was an internet standard, so to speak, an official document that was asking for newcomers to adopt some rules of conduct in order to harmonize their behavior with the values which were the expression of what was felt as being a community. So not just a number of people gathering there, a community with shared values and so on and so forth. And that demographic change also led to some institutional changes. Why? Well, basically because the new population was coming in that environment for sharing, but also for social interactions, for economic interactions, and so on and so forth. So digital assets, but probably in a different way, started to become central in the public debate during that time. And probably it is fair to say that intellectual property and copyright specifically became a sort of battlefield with a huge number of laws, regulations, court decisions being taken. Just a few of them. What I believe are the most important steps in that during that institutional change. The World Intellectual Property Organization Copyright Treaty. That I believe that treaty is really important because it didn't just legalize the digital self-help. The fact that within the digital domain, you may be using your own, well, computational power to enforce what you believe it is your right, okay? Regardless, maybe the legal configuration of that right. When I'm teaching intellectual property, I tell my students that the WIPO copyright treaty changed intellectual property by bringing us back to the stationer's copyright. Basically, the stationer's copyright had a perpetual monopoly over title of books they were printing. I'm talking about the 16th century England. And they were a private corporation incorporated by, yesterday we were talking with Pidge about that, incorporated by Queen Mary, also known as Bloody Mary, the daughter of Henry VIII. And basically what that act of incorporation made possible was by the stationer's company to create their own copyright and to shape it as they wanted. Because basically with the help of the Star Chamber, they could enforce privately created rules. Basically, I think that what the WIPO copyright treaty did with intellectual property is the same. We are just privatizing copyright by letting who has computational power to, rule what you can do and what you cannot do with intellectual property. Why those institutional changes? I believe that there are two main reasons. One is, and this makes me cover the ideology part of my title. One was that individual property rights, which means exclusive rights, right to exclude, basically, are, how can I say? Well, I will be reading, boost social welfare through Pareto efficient transactions, okay? And prevent the tragedy of the commons. Well, that's usually what we are being told. I think I can say that ideology because if I look at the facts, I see that as long as intellectual property is available in the digital domain, well, people some weirdos started to use intellectual property and copyright specifically to create digital commons, free software, open data, and stuff like that. So why? If only individual property rights are supposed to increase social welfare and efficiency, instead we're using those individual property rights to create digital commons? That's interesting, because it was not a plan It was a spontaneous emergence of those digital commons. Then there is the rhetoric part. And I'm citing James Boyle. I know that I'm not completely honest with this citation because James Boyle was talking about originalism in constitutional interpretation. And he was basically asking himself, why do we have to rely on the intention of the framers to read what they wrote? Why do they have sort of possession of the meaning of their of the Constitution, whatever? And so the answer, according to Boyle, and I think this is interesting, was that since the author creates the intellectual work out of thin air, ex nihilo, then, well, there is a sort of natural right to exclude others from. So I will come back to that because I believe that in an environment populated by GPTs, LLMs, probably that perspective in understanding intellectual property is going to fade. Okay, so as I said, anyway, a higher level of protection of intellectual property didn't stop the creation of digital commons. Far from it. That demographic change created a new problem. The information, what I labeled the information retrieval problem, because the number of people leaving or the cyberspace and the number of resources were growing and growing. And so finding them was difficult because also we didn't have powerful search engines. And there was a proposal by Tim Berners-Lee, who is regarded as the creator of the web, okay? And what was the proposal? The semantic web. Well, basically, we can use the extensible markup language to create a web ontology language to describe data structures. Then we can use a resource description framework to describe with those data structures the content of the web. And then we have a querying language to retrieving information. What was the idea behind Berners-Lee's proposal? Well, basically that if you have a chaotic environment and you start creating rules to organize its behavior, if the environment becomes predictable, then the computational power you need to retrieve information and to make decisions is far less. And we know that because we know that in social sciences, we know that in the legal system is a way of making a social environment predictable. Herbert Simon described, I'm citing him here, described the organizations as large distributed computing devices, basically. Why? Because we have rules, so we can predict the behavior of other individuals, and we may make plans according to those provisions. So that was the main idea. We create an additional layer to structure the web, and by doing so, we will be able to retrieve information in a powerful way by using available technologies like database technologies, querying languages, instead of doing what? Instead of using artificial intelligence. Because basically the only alternative in a chaotic environment is to have adaptive algorithms, the machine learning in order to cope with the problem. And well, you know what happened, because the semantic web was not successful. Far from it. Probably, I don't know, but I think that the last talk will be last talk of the next section, we will be talking about some of those technologies, but I'm not sure, just by looking to the title. So the alternative was artificial intelligence. And I hope I will surprise you a bit, because when talking about artificial intelligence, I will start with a court decision. Google Books, or better, Authors Guild versus Google. A decision that was taken in 2015. You probably remember at the beginning of the new century, Google started a new initiative in order to digitalize, every published book. And well, there was a reaction by publishers, as you may understand, because they didn't want that. And the Authors Guild, sort of association of American writers, decided to file a class action against Google. There was a tentative settlement agreement, highly criticized, because basically what Google said was that, well, I can pay you, no problem. But as you may understand, there were many people that were not happy with the fact that Google was going to pay publishers for, digitalizing books. And so there was a long discussion. The settlement agreement was eventually rejected. The Authors Guild and Google filed a motion for a summary judgment. The judge gave that summary judgment, and he wrote at the very end of the decision, the opinion, Google actions in providing the libraries with the ability to engage in activities that advance the arts and sciences constitute fair use. And the very same day, newspapers around the world started reporting news with titles like Google Books ruled legal in massive win for fair use. So that was a victory for fair use. Well, maybe. Anyway, we must be fair with Google, and Google started releasing the tools they were using to digitalize those books as free software. I think that if we read that free software, maybe we could have a different opinion of what Google was doing with Google Books, because a couple of those softwares were actually implementation of machine learning. They were trained, and Google was using Google Books search to train those pieces of software. But nobody saw that. Anyway, I'll try to be very quick, but I need to provide you with a tentative definition of machine learning. Be careful, I'm not trying to define machine learning. I'm just trying to define what I will be talking about, okay? So my perspective. And I define machine learning as a brute force approach to well, that's a word I will not be able to pronounce, but you know what I mean, produce functions that correlate elements of a large data set in a generalized model, which can generate new connections amongst those elements. I'm not sure whether this is an appropriate definition of machine learning, but I think that that definition allows me to stress two characters of machine learning and artificial intelligence more generally. Machine learning is computationally expensive, very expensive, both in training and in running and producing the output. And it also requires large, fine-tuned, unbased data sets. Well, I think that this second part is not problematic in any way, because we know that huge data sets can be created collaboratively and can be distributed as digital commons. Yeah? You know, the Gutenberg corpora, the OpenStreetMap geographical data sets, and so on and so forth. The other character is more complicated, I believe, because computational power instead, it's hardly a digital common. Why? Well, because if you think about it, computational power relates to physical resources, transistors, and power supply. I will probably skip this slide where I try to summarize what's happening on the in the legal domain about artificial intelligence. Many litigations started in the last 2 years. We do not have any court decision yet, but I have the feeling that Authors Guild versus Google will be used as a precedent. So I'm not really worried about those litigations. Anyway, I would like to show you some, well, this is just an example of, this is extracted from the exhibit by the New York Times litigation. And on the left side, you can see the output from ChatGPT. On the other side, you can see the output from the New York Times. But if you read the prompt over there, you see that what the software engineer of the New York Times did was, you know, prompting ChatGPT with the beginning of the article, but he knew that. And that way he was able to retrieve the rest. So I don't believe this is, you know. Anyway, concluding remarks. Very shortly, because I wrote everything there. So, and you can read it, sure. So also because my time is finished. So, anyway, computational power. I think that there is a general trend of concentration of computational power in the digital domain. I was listening to Ugo's talk, and I was thinking about cryptocurrency mining. If they use the proof of work, usually miners are joining mining pools. And I read that a few times many mining pools in different cryptocurrencies were able to gain more than half of the computational power of the related network, which allows them to perform what is called a 51% attack and double spend the digital asset. Anyway, computational power means political power. And so I think if you have enough computational power, you can run the network. And that's precisely what's happening with the simple mail transfer protocol and Gmail. Gmail is running the protocol, is setting the policies. And if you want to run your own personal email server, you have to comply with the rules set by Google. Then there are further questions, and one of them, and this is my very last statement, relates to our conception of intellectual property. Because I said the rhetoric part is that we create our intellectual works out of thin air. And is that possible in an environment with ChatGPT? I mean, if I were able to give ChatGPT all the reading I've done during my life, probably I didn't have to write those slides, but I could ask ChatGPT with the right question just to do the job for me. Thank you very much for your kind attention.
Thank you very, very much, Andrea. Thanks a lot. Break? Okay. The chief said that we have break. Law in private comparative law. She's an expert in intellectual property and privacy. Thank you very much, Georgia.
Thank you, Professor, and thank you, Professor Bradi and Professor Malvagna, for the invitation. We already mentioned data several times during these 2 days. I will focus on the personal data. So personal data can be things, can be goods, can be trade in this market. I will start with some consideration on the data market, the new data market, the digital market, and then I will try to go through the history of the protection of personal data, from the right to privacy to the control over personal information, to understand whether personal data can be traded as goods, as commodity or not, because there is another perspective in the legal domain, which is the personalistic one. And then I will move to future perspectives by adopting a more contractual law approach. You know that data is the new oil. Data is central for the development of big data, artificial intelligence, Internet of Things. The data sets used to train all the algorithms and the models are in an aggregated form and are usually composed by both personal data, meaning data referred to a natural person, name, surname, data concerning health, your address, your email address, etc., and also non-personal data. So data, for example, generated by the algorithms, as mentioned before, or geographical data, environmental data. Both these data are combined to create a useful data cycle, able to process the information, derive new information, and if we think about the so-called surveillance capitalism, use the information about the natural person to predict our needs, our future interests, our role in the society. So all the threats for democracy and the protection of fundamental rights. But if we focus only on personal data, the data economy is treating data as goods. So this is a de facto perspective. The economy allows us to, the company especially, to buy data in marketplaces online. There are several collectors and platforms that makes available data to third parties. So not just the usually called big tech companies, so not just Google, Meta, etc., but also other companies who use the data from the platform for providing new services targeted to the consumers or not. And all these providers should comply with the applicable law of the legal frameworks. But as also Professor Rosato mentioned, we are in a cyberspace. So there is also a geographic problem on dealing with these legal issues. The data market uses two words: selling, so the actual trade of personal information, and also sharing, which is a different word only for providing data. And I think this is a dualistic perspective on the possibility to understand whether data are goods, so from a proprietary perspective, or are not goods, and maybe they should be subject to a different approach, a contract law approach, and not an ownership approach. If we go back to the protection of privacy, we should start with the reference to the well-known paper of Warren and Brandeis. So the right to privacy was born as the right to be let alone, and these two legal scholars proposed the introduction of a new concept in the US legal framework by using a new concept in the US legal system, which is the personality. The protection of the personality of the natural person. So data, in that case, data related to the intimate sphere of the person should be protected over the use by a yellow journalism, which was made possible by the snap camera. This concept of personality was not used by the US case law anymore, but in the European doctrine, after Warren and Brandeis, the scholars created the new rights of personality, or better, diritti della personalità, because cannot be translated very well, right della personalité. So right to privacy was born as a right to protect the private life, communication, and also the person in his domestic life. So also from a physical dimension in home and other personal spaces. So since the beginning, the protection of privacy was perceived by the legal doctrine and also the case law as the protection of the person, a personalistic approach. With the evolution of the digital age, right to privacy needs to be conceived in another way, and so the right to data protection was created, as described by another legal scholar from the US, Alan Westing, as the control of information about oneself. And in the 70s, in the European Union, France, Germany, and other countries started to approve and enact statute on the protection of personal data. So in the beginning, the protection of privacy or data protection in this conception was conceived as a negative right. So the others cannot enter in my private sphere, in my intimate sphere, to protect me as an individual. Whereas after the digital age, the protection of privacy and data protection is conceived as a positive right. I have the right to control the circulation, the flow of my information about my life. In the US, they use only privacy with a multiple definition, so embedding both the protection of private life and the control over personal information. In the European Union, with the Charter of Fundamental Rights of the European Union, the legislator created two rights. One is the right to privacy, private life and correspondence, and the other one is the right to data protection. Still, a personalistic approach. We protect the information because this is a part of our life. Professor Resta uses also a metaphor with the human body. As we protect the organs inside us by the abuse of the market, of the others, we protect the information about ourselves. However, as I told you, the data market and the narratives around data, including personal data, promote the free flow of personal data, so the circulation of data and the commercialization of this data. So we need to understand whether this personalistic approach of protecting rights that should be not traded in the market can be combined with a possible existence of ownership, even not only for digital assets, but also for personal data. And if yes, who is the owner? Just the person, so us, or the company after the trade? Maybe the owner or not. Yesterday, another speaker mentioned the fact that data is intangible, not excludable, not rival. So from a theoretical point of view, data should not be subject to an ownership approach. However, there are both private and public interests to be considered, and the existence of the data market is so important that we need to understand whether data is a thing or not. From a theoretical point of view, so from a strictly legal point of view, the droit de la personnalité cannot be traded, should be inalienable. However, there are examples, even in the traditional civil right perspective, that some droit de la personnalité, some civil rights of personality are traded. Think about the right to publicity, the fact that public figures, persons, trade their own image to for advertisement purposes, for getting profit on the use of his own person. So think about influencers nowadays, but in the past, actresses. So even in the legal domain, there are examples of diritti della personalità who are in a way used in the contract. At the same time, leaving the possibility that personal data can be conceived as things, leave the possibility that we can be valued as person. So my data concerning health has a value in the market, the aggregation of all our data inside this room, which value, which amount of value we give to this kind of possible good or not. So I'm a comparative lawyer, but for the following reflection, I will focus in the European and Italian legal system for purposes of time. Before 2019, we were not sure whether data can be a thing or not. After this directive, which is an act from the European Union, the directive related to the digital content and digital services online, we are sure that in the European Union legal framework, data cannot be a commodity, cannot be an asset. So still the personalistic approach. However, for the first time, the legal framework acknowledges the existence of contracts where the person gives or attributes the data to the company, to the provider, to obtain a service. So I propose to change the interaction between my perspective, not just with personalistic versus proprietary approach, but personalistic with or without a contract law approach, including obligation rights, not ownership, but obligation rights. In the famous case of the antitrust authority against Facebook in Italy, Consiglio di Stato, 2021, for the first time, an Italian judge recognized that the use of the data protection framework, all the rules to control the circulation of personal data, can be combined with another source of rule, the consumer protection. So they are not antagonistic, these frameworks. They can be used together to protect the person and then the flow of personal data. Because the judge wrote, Facebook uses the data for remuneration, monetize the data for its own purposes. And so the service between me creating a user account on Facebook and Facebook on providing me the account and all the services in the platform, this relationship is a contractual one. We subscribe a contract when creating the user account, and at the same time, you also read the privacy policy governing the processing of our personal data. Looking to the big picture, so we have the data protection framework, a personalistic approach, a consumer protection framework, which is a more civil or traditional approach of considering the relationship in an obligation, with an obligation point of view. And we also have intellectual property, and intellectual property conceives some protection and some control over data, even more in the digital age. There is the database protection only in Europe, a sui generis rights covering the aggregation of data when the aggregation of data took some money on constructing it, and the aggregation is complex, so original. There are trade secrets who protect information related to commercial interest of the company. And there is also the so-called new sui generis rights over clinical trials data. So even when data is sensitive, there might be an intellectual property right covering it. When, for example, trying to produce a drug and performing a clinical trial. So in general, even the intellectual property domain can be an example of a possible existence of a control right over data. So I think that as the current Italian perspective, so quoting Alba, Resta, Zenozenkovic, Ciuto, and other civil law and comparative law, private law scholars, I think that data should stay from a personal perspective protected, but contract law is indispensable. So the data protection framework is not sufficient. Personal data cannot be a commodity in an ownership regime, but we should govern, our legal framework should govern the contract between the data subject, so us as natural persons, and the providers, the platforms. After the directive of 2019, the Italian consumer code has been adequated to the EU legal framework, and in this article I quote on the slide, the Italian legislator adopted the concept of obligation in relation with data and these contracts. Therefore, there is also a hard evidence of this possibility. The consent we give to the platform for using the services, of course, should be free, informed, and based on a informatic self-determination perspective, so following the idea of Rodotà, Frosini, and all the others legal scholars in the past. We need to apply the contractual remedies. So not ownership, but the contractual remedies, giving to us the possibility to question that we are the product. We are not the product in this personal data market. We are giving something when downloading the app that seems free. They are not. We are giving something, and we should put at the center of this or at least in a more balanced relationship with the platforms. So I will stress the importance to change the narratives also from a linguistic point of view. Not anymore platform are data owners and data owners, they are merely data holders. We are the real controllers of our personal data, and we need to be informed. So there should be a more, also from a legal point of view, there should be more intention of its transparency and the right to get informed when subscribing the contracts with the platform. So adopting the Consiglio di Stato approach, we should combine the data protection with the consumer law to be to understand that data is not a thing. So no, data is part of us. So thank you.
Georgia, thank you very much. Also for this very interesting overview of the different positions. Now we move to the other section. So we have Elena Axfig, Stefano Borgo, Camilla Perrone. Okay, okay, yes, sorry, yes. So Elena Axwing is a PhD student of the Doctoral School of Information Engineering and Computer Sciences of the University of Trento. Her scientific areas of interest include participatory design and artificial intelligence, more than human design, gender basis in large language model.
Yes.
So thank you very much, Elena, for accepting our invitation, and the floor is yours.
Thank you, and thank you for the introduction. So I was invited this Wednesday to this conference, and when I saw the flyer, I saw the theme, I thought humans and things. Yes, I have to make this happen because it is really interesting topic. And as a techno-anthropologist by training, I love to speak about philosophy, speak about ethics, speak about the relation of human and technology. Not something that my computer science colleagues often want to discuss. So I appreciate this opportunity to be here today. So I guess I will do this. I will go through a few things today, mostly focusing on participatory design and rethinking the concept of participation, especially when we talk about things or including others. And I will start to say that within the field of information technology, participatory design is an approach, some also consider it a paradigm, that places the needs of people, especially those who use the technologies themselves, at the center of technological development. So it is an approach sometimes motivated by more ideal intentions, such as more democratic balance between users and designers, and sometimes more pragmatic intentions that we need to make better quality products. But as opposed to other user-centered approaches in, for example, the field of human-computer interaction that I also work in, participatory design is not just user-centered, it is user-driven. So user-centered approaches, they emphasize user feedback, user testing of technologies, of products. But participatory design moves beyond this relatively superficial user involvement, and it accentuates genuine inclusion of users and other people's of interest in all stages of the design process. So ensuring their agency and empowerment as active co-creators. So it is a call of a broader consideration of social and cultural and contextual factors that influence technology use and therefore should also influence technology design. And by actively involving users and other stakeholders, especially marginalized and underrepresented groups in these decision makings and co-designs, a participatory approach challenges the traditional power dynamics and fosters more equitable and inclusive design outcomes. And to address challenges and achieve a comprehensive perspective on technology development, it is seen as crucial to adopt these human-centered approaches, which participatory design also is, but to consider a broader concept of humans beyond simply the intended users, because other people can be affected by a technology that is designed even if they are not the intended users. And this is something participatory design approach achieves. But what about things? Participatory design is about designing things. And this can refer to a very wide array of both analog and digital products, technologies, infrastructures, processes, and a lot more. So participatory design focuses on including the relevant people in the design process, ensuring that those who are most closely connected to these things, either if it's now or in the future, that they have a say in shaping how the things come to be. But today, with the unstoppable rise of AI-driven tools and systems, it has become crucial to rethink the very meaning of participation in design processes. And this rethinking touches on several philosophical and practical questions about agency, the role of technology, and the evolving relationships between humans and machines, or humans and things. So first, we'd like to discuss is if agency is a prerequisite for participation. In both philosophy of technology and more pragmatic fields like science and technology studies, there are theories that have long explored the relationship between humans and technology. But as AI systems advance, we need to question whether agency is a necessary condition for participation. I've brought a few theories, methods, depending who you ask, to talk a bit about this. First, we have the actor network theory developed by Bruno Latour, which distinguishes between actors as humans and actants as non-human entities like technology, but it can also be animals and other things. Despite this still separation between humans and things, it demonstrates also how humans are embedded in a very vast network of relationships that include both human and non-human actors. And then moving on to post-phenomenology, first developed by Don Eide, this theory emphasizes how technology mediates our interaction with the world. So technologies aren't passive. They shape how we think, how we perceive and act in the world. And as such, they are an integral part of our experience with the world now, which leads us to cyborg feminism developed by Donna Haraway, that questions how the boundaries between humans and machines are blurring or already have blurred a long time ago, raising critical questions about identity, agency, and power in these relationships. And then we have a thing about thingness and participation. So I would question if a thing without agency, such as a technological tool, can be considered a participant, an active participant in a design process, or if it is merely an element or tool in the process that already exists now in participatory design, that we use technological tools to facilitate a process. But if we recognize that technology can influence outcomes of a lot of different things, should we consider it more as an active role in these processes? Then I will move a bit on to the value of including others. Because what is the benefit of maybe considering others, be it non-human actors, in a participatory design process? Because participatory design is, from its conception, a very anthropocentric approach. But recent development have included others, included things, as a part of this process. And the notion of a human-centered thing ceases to be useful when we have a complex network of human and non-human actants, especially saying, I have this quote from Colton and Linley, that when designing for networked ecologies, prescribing a unique center cannot probably characterize the design space. should humans still be considered the center of everything we design when we talk about ecological troubles, for example? So there are a few approaches that move beyond these understandings. A notable example is modern human design, where things are represented, for example, as personas in participatory design, simulating participation to provoke more non-anthropocentric relations. This includes a shift of our focus from purely human-centered to offer richer design insights that are more sustainable for our world. And just a very brief explanation of what I mean when I say persona. A persona is usually a fictional character or a profile that represents a typical user, a stakeholder of a product. It exists in many different fields. It is usually created after doing some research, doing some empirical work, understanding who are these people we're trying to create a persona about. So they help designers empathize with different user types and anticipate how various groups might interact with a design. But in some contexts, like modern human design, personas can also represent non-human entities, such as animals or ecosystems, encouraging designers to consider a broader perspective beyond humans, and therefore also a broader perspective on things. So I want to give a more concrete example from this paper that is very enjoyable. The article on animal personas by Jessica Catherine Frawley and Laurel Evelyn Dyson. They explore the development of animal personas as a way to integrate non-human stakeholders into design processes, focusing mostly on sustainable food systems. This study uses animal personas such as chickens on a free-range farm to provoke non-anthropocentric reflections. So by simulating the participation of a chicken in the design process, they could encourage designers to consider the impact of their work on animals, creating more inclusive and ethical designs. So they have this Betsy chicken persona that they included in the process of a website with recipes. When a recipe, for example, stated that 1 egg was needed, Betsy would come and say, oh, that's a whole day of egg laying for me. Or if it was 3 eggs, that's too much. So to think about the way that we sometimes exploit animals, even in a simple thing such as a recipe. And then moving on to simulated agency in AI. Because what happens if we deal with things, and here I'm mostly talking about AI, that can simulate agency or interaction? How do we navigate participation when these systems can be seen as capable of agency? Do we include them as an agent in itself? Do we ask an AI, how do you think we should develop this AI or this AI? Is it possible to foster a process of co-creation between humans and AIs that promote more symbiosis in the way that we live in the world? And those are questions that haven't really any answers yet. But considering that we should even ask the opinion of AIs about design raises also fundamental questions about agency and power and responsibility. Because whose agenda are we promoting in this human AI collaboration? Who are we empowering? Are we empowering the AI, and do we want to do that? Do we want an equal power balance between humans and technology, or should humans retain a dominance? And these questions are not just practical, but also deeply ethical and philosophical and very difficult to answer. So my thinking on this is, if this is a direction that we want to take, should we grant AI an agency in affecting how we develop technologies for human use or for other types of uses, allowing it to influence how we shape our future? Or are there other entities more deserving of empowerment? Because in the context of modern human design, could we, for example, use AI to simulate the participation of things that lack this direct agency? So fostering a more inclusive design process that accounts for non-human stakeholders. Which brings me to what I work a bit with, which is called AI-generated or AI-powered synthetic persona, which is a quite new field that is still being debated a lot. And as you saw previously with the chicken persona as well, typically personas are more static representations. They're constituted of words and maybe an image on a paper. But what if we could use AI to simulate these personas for a more dynamic pseudo-involvement in the processes? Something that is starting to appear. But if we stick to the idea of involving animals in design, imagine putting a chicken persona into a large language model like ChatGPT and having it enact this persona. This could potentially allow stakeholders in a design process to interact with the chicken when they are making decisions. Or what if we asked ChatGPT to create a persona for the chicken based on, shall we say, the model's very limited understanding of our world? Could it accurately represent the need and values that are important to a chicken? Or would it generate something irrelevant? So I did that. Here we have ChatGPT's answer to a chicken persona. We have Clucky McFeather, who is 3 years old. It's a golden buff Orpington, I don't know what this is, but who lives on Sunny Meadows farm. And it includes a description of personality, needs, and values, because I defined that this is what we need in a persona. And we can see that there's a focus on the values of social interaction, of freedom, of nourishment, being protected. So then I asked ChatGPT to act like Clucky McFeather, and I asked some questions, very basic questions if you're considering designing a farm layout. And then considering these mobile hen houses that can move around on a pasture. And it really lives up to the role in this way. And if we as humans try to understand chickens and imagine how a chicken would answer this seems pretty okay of an answer. Especially when we also ask them a more negative suggestion. So here I am considering all the chickens that live in a house with concrete floors and too many chickens, and how would Clucky McFeather think about this? Obviously, it's very sad about it. It doesn't like it. It's a big nope. You know, it would get cold feet. It would hurt their feet. There's not enough space. The feathers would become bad without sunlight. Okay, yeah, I am almost done. Perfect. So while this might be a simple persona and a simple design scenario, we can imagine that it might be possible to leverage these capabilities for more complicated discussions. Similarly, we could create personas for water, for mountains, for forests. And while models like large language models are not infallible and they lack this true understanding of the world as they are mostly statistics, could we still use them, though, to provide a voice to the otherwise voiceless entities? And in this context, as we reconsider participation, especially the participation of things as active agents, can AI be leveraged to include these non-human beings in a proper way? And could it foster a more sustainable, fair, and balanced symbiosis between humans and things? And ultimately, can technology help mediate not only our relationship with the world, but also with the myriad of things that inhabit our world? So I will conclude by saying that in this new landscape shaped by AI and technological advancements, rethinking participation goes way beyond human-centered design. it requires an exploration of agency, the role of technology, and the power dynamics between humans and machines, as well as humans and things. And by confronting these questions, we might better navigate the ethical and practical challenges of designing a world, or designing in a world, where humans and AI increasingly and quite terrifyingly share the stage. Thank you.
A very interesting point of view, Elena. Thank you very
Thank you.
much, and giving a contribution to this blurring area between human and thing. Thanks a lot.
Thanks.
Now we have Stefano Borgo, head of the CNR Center in Trento. Stefano studied mathematics in Padua, logic at Indiana University, and informatics at Free University of Bozen. Thank you very much, Stefano, for being together with us. And the title of the speech is Laboratory and Applied Ontology, CNR.
How do you control? Quello che funziona con la tastiera. Okay, thanks. So thank you for having me here. And these kind of events are always challenging because people do their best to present what they're doing, and that makes them extremely interesting. So that when you go home, you say, "Oh, look at all these people doing nice stuff," and then you get kind of disappointed about what you are doing. So in order to help you to spend a good weekend, I will do a quite boring presentation. So at least I save you that. So Camilla Perone unfortunately cannot be here. She apologizes, and trust me, she would have loved to have listened and this presentation and to talk with you. Lot of interesting and stimulating discussion and topics. And I do resist on answering from Andrea, Massimo, Elena, and Georgia, and whatever came from yesterday, because of course we more or less naturally address similar topics, and well, maybe a discussion would be nice to do. So my goal is to actually introduce a little more what applied ontology is, and then the focus will be on the notion of interaction, which is like, at the end, to me, is something like moving higher than the distinction between agent and object. I think it should be introduced later in the conceptual framework, but I hope I can send the message. So this is what we do. So we are the CNR group. So we are not part of the university, but we essentially do research. It is ontology from the philosophical sense, but applied ontology is much more concerned with what happens in real life, even production or whatever. Sometimes you go into these overlapping areas of concept engineering, knowledge representation. So technically, we are considered part of AI, symbolic AI for those that care. Topics that we address are the notion of agency, what are organizations, what is a function, more in terms of what kind of functionalities things a system provide, what is a resource and processes. And the domain areas can be quite broad, like social, technical, and cyber-physical systems, building culture to be able to put into an artificial agent, so it can actually behave according to the culture. Data integration for engineering modeling, that's a standard topic. Human rights in AI, and then the studies of urban systems and planning and stuff like that. It's broader, but because the applied ontology methodology is very generous about data information, and then it is developed in order not to be concerned with a specific domain. So then you expand it and use for whatever data information is present there. So what is it? You start, of course, from philosophy. Many of you have some knowledge about that, and you have these general definitions. It's the study of nature, of reality, and of the categories with which we organize it, or we can imagine what to exist may mean. And then when you do interplay ontology, you turn it to a kind of a science because you want it to say, yeah, I take those principles, there are a lot of them, they are very interesting, but many are inconsistent. So here you make a choice. I do this, I take those principles, just in terms of identity is a mess. So you have to make a choice. You go against some of your standard common intuition because, of course, you want to have a system that is formally consistent. So that's a technical term. You have to make a choice, say, okay, I take that one, I'll build the system, formalize it, and I know that if I put right information there, I will never get anything wrong out of it. That's why then people in application want to use this stuff, right? So it is a science of the same thing if you want. So you make choices, you constrain, and then you say, okay, this is a coherent way to understand reality. And then it's your own problem to decide which reality you want to address it. So it is informed by a lot of stuff, philosophy, computer science, primarily, data science more recently when it came out to be considered a science. Cognitive science, of course, because we are constrained on things we want to do, so the way we understand the world is a part of it. Linguistics, engineering, geoscience, and now a little bit of everything else. So it developed in this way, essentially from different communities in the 90s, people started saying, if we want to understand the data, because data is no objects, data are claims, and so you have to understand statement. If you want to understand data, you have to understand how whoever produced the data, a person or a sensor or whatever, understand the world. So that's the assumption. And this came out from database people that could not integrate the data for a good reason. And came out from several applications. The geoscience I was mentioning was one of the first communities that started discussing, but when we talk about a lake, what are we talking about? And this came out. So in the 90s, from the first early 90s until 2000 more or less, you know, these historical reconstructions are always a bit to be taken with a grain of salt. So they were discussing worldviews, basic categories. What do we want to achieve? Why do we want to build this stuff? What kind of interoperability do we want in those systems? And then what it means actually, you know, when we talk about distance, when we talk about being there, when we talk about material stuff, cognitively and common sense, what are we talking about? And then later when some commonalities and some clarification came out, people started building those systems. So 2000, 2010, the major system came out, and now there are 5 or 6, they are very stable, very well described. So we had the construction of the system. When I say construction, I say they are logical theories, and they can be implemented, and you can run them on a system. So the construction, so which principle do you take? How do you combine them? How do you formalize them? And then how you to describe them, because they are complicated, and describing is an important part of that. And after that, learning out of this came out also the idea of a building, methodology for building ontologies. This goes into the OWL system, the Web Ontology Language, which is one of the languages we use in implementation, because from the expressive point of view, it's too weak, but that's not something we are going into. And then the domain application. A lot of work in medicine, high level, light ontologies, more deeply concerned in engineering, where you have a lot of details that goes into the construction of like an airplane. That's heavy stuff. terms of data. And now the recent turn is to make a scientific validation. So can we actually compare the different ontologies? And when we say, if I have to do this, it's better use this one or the other one. That's what we are trying to learn. And well, let's skip this, but there are different ways to understand what an ontology is. So if somebody's talking and you're confused, that's okay. There are two ways to look at that. It can be general. So I present a general way that we all share in order to understand the reality, or it can be personal. This goes into the idea of building ontologies for ourselves, a specific way, culture you build up, but also for an artificial agent like a robot. This conceptual system has to be coherent with whatever it can perceive from the environment and whatever it can do in the environment. It doesn't make sense to give the notion of color if there is no way to perceive color, right? So that's the idea of having an ontology that is built in for that type of agent. So the first one, generally, there are some people like Barry Smith, which is quite a famous person. They think they should have one. You take a scientific realism, you make that ontology, and we should all agree with that. Most of the people say, no, we actually use several ontologies, even in the same sentence sometimes. And so we should be aware that there are different ways to understand reality and just make a decent list of them and see what the commonalities, the differences. The other one is actually the one that says, I build a conceptual system for whoever, knowing what this agent, person, or thing has as a characteristics and things like capabilities and so on. This is one example. Not going into it, but just to tell you, people are very interested, so that at the end, we actually have an ISO standard with that. And last year, we finished a European project. We started with 10 companies. After 1 year, we had another 20 user cases. I'm talking about Airbus, Siemens, Bosch, IKEA. They all have ontologies inside their database. Good or bad, that's a different issue, but they all use them. And there is an ontology database marketplace that coming out of these experiences. So in a sense, semantic web is alive, maybe in a different way from what you mentioned before, but it is like alive and kicking. Okay, now let's go into interaction. So you know where I come from and what I'm interested in. Now, interaction is a notion that Elena brought up before, and it's something that we do not really understand. So that's an interesting topic. So you see something and you react, looking at what connects whatever you identify there. And then you see something else, and somebody yesterday mentioned Dennett's stencil, the intentional one. And I would say, well, actually, no, you see some plastic figures, but in a sense, you say, well, no, there isn't some intentionality between them. So it's your choice how to read it. So there is for sure some interaction there, but which one? No, how many? It's a little complicated. Sorry. And then there are interaction where there is somehow of disalignment between the way whoever is there, whatever is there, understand what is going on. So this is makes the notion a bit confusing. And so you might start asking questions, which is what you do when you do ontology. The first thing you do is, for a few months, you ask questions. And you say, what is an interaction? Where is it? How is it? How long does it last? What are the participants? How does it compare with something else that we might know, like a transformation? Transformation engineering sense is very clear. Today, we know it. I'm not taking track of time, so if you do for me, that would be great. Then you start saying, okay, but not all the questions have the same value. So there are some that are more ontological. What is an interaction? What is a participant? And how does it compare with other things? And other which are, if you want, contextual or contingent. They say, where is it? How is it? For how long does it last? By means of what? And so on. So you start making questions that you say should be generally talk about interaction per se, and other that says, oh, I have different instances. I can make different types of interaction. And then you start also adding what is more technical way to address it. If it is something that is about several entities, so how it happens. Do we have reflexivity, symmetry, transitivity? Can I counter them? Are they between, so if my two ends are interacting with, I assume as a standard example, are the two parts of me that are interacting, or is it me as a whole that I interact within my parts? So that's where do you trace the core of the interaction? And what must exist when you say that there is an interaction? Then you say, you look at the literature, there is a lot of stuff on interaction. It's more as a term that you use, you know, like the terms like context that everybody uses and nobody tells you what it means. Okay. The interaction goes a little bit that way. Actually, I have a theory of context, but I'm not going to talk about that. So you can take the perspectival view, so you center yourself, and you say, okay, I'm interacting with you from my perspective. Or it is a systemic view, then you say there are different things here. The system somehow manifests something, evolve in some way, and this, I just describe these old things with the parts that connect. Or you have a functional view, so you deal with more a teleological perspective, so everything contributes to a certain development. Or the behavior view, the fact that I do behave in a certain way because I impact on you and on the table, on the mic, and I get impacted outside. The combination of these determines my behavior, or the perceptual view, which is more like related to, well, actually would be philosophical, but let's say it's related to how things evolve. And so you start separating things. This comes out from human-computer interaction. You say, well, look, there are actually at least two things you have in mind when there is an interaction. It's a relationship between things. Actually, I should say entities. I want to be more general than that. There is a relationship between things. And then there is an event. So something is manifested because of this. And then there's what I was calling before the behavior. So everything or every entity somehow manifests a behavior because, or a certain behavior because of that interaction. But we want to stay, again, at the general level. So we don't want to give it a teleological or objective meaning. No goal, no purpose, no intentionality, no sense of use, no human things distinction. Because you can always impose a perspective, but you first have to understand what you're talking about. So now, no, this is ongoing work, but our concern, here's where Professor Perrone, Camilla expertise comes in. There is a lot of there is a reason, important reason to address general problems like the arena where you discuss between different stakeholders, you have to make a decision like a waste plant or environmental resources, things that are extremely complicated. And when we address those with stuff like participatory design and things like that, you actually take a point of view and you simplify the system according to what is relevant for the point of view. So you have the perspective of the social interaction, the social-technical interaction, the human-natural interaction, human-computer interaction. They are all perspective you impose on this complex system to say, I look at this, I assume that nothing else exists. I look at this, and since I have a methodology to address the relationship between those things, then I can do something, okay? But then if you take the other perspective says, no, I look at those other things, which might be the same because I might see an animal in one case as an agent, in the other case as a resource, and it makes a huge difference. So I have apparently, in a common sense idea, the same object, but it's encoded in my modeling in different ways. And then my result becomes incompatible because the two things have different properties. So I'm looking at different simplification of the general problem. That's 2 minutes. I hope that's 2 long minutes. No, I'm almost going. No, I'm almost there. So the idea for us was this. So my interest on understanding interaction per se came out as a tool to say we need to find a general framework where all this type of analysis for important things like climate change should be possible to be incorporated in a single perspective. So a single framework where you can do, you can integrate complexity study at large. And this is something that, of course, I don't have a solution yet, but it's what we are working on. And I can give you a little more details if you want, but to stay high level, I will skip that. So what do we have? Well, we have ontology, applied ontology as a science. So it's like taking the philosophy and pushing it. Look, this is the real problem I want to solve. So give me the principle that are coherent and allow me to solve this. And the observation, the interaction is scattered across the different disciplines and generally analyzed in terms of perspectives. And that perhaps if you have a unifying conceptual framework, we can put all those analyses together better than what we do today. And finally, the recognition that applied ontology, due to the kind of tools it uses, is the way to actually build this, which turns out then to be a system where you can take whatever notion of object or agent you have, you can take it, plug it in, make those things emerge out of the system and do your analysis without forgetting that inside the system, there are a lot of other stuff. And this is technically possible, but still needs to be developed. So if I'm lucky, one day I will be happy to come back and tell you how we did it. Thank you.
Thanks a lot, Stefano, and many thanks also to Camilla Perrone for this very, I have many questions that I will ask them later on, but now I would like to give the floor to Professor Monateri. Professor Monateri is a professor of comparative private law at the University of Turin, but is one of our founding fathers of the Faculty of Law as well. Professor Monateri has been teaching in Trento, and he also acted as vice rector at the University of Trento. And we are very thankful to him for being here again together with us. And I give you the floor.
Thank you, Elena. Well, yeah, I'm a founding father here, and now I am the father of my university. So I'm so old that I became the father of my university. Well, what I shall try to do will simply be to see what we gain and what we lose if we adopt one point of view or another. If we decide for a given scale of observation. Because we have witnessed in these days that there are several layers of rhetoricity in the discourse on law shows, human and things. And I will touch essentially 3 points. I mean, ontology, agency, and then liability, because of course I'm a lawyer, and so I think that liability in this case is important to understand the whole project. Well, ontology. I will start right from here because you have seen, Elena, you yesterday told about the fact that we abandoned the pyramid of Puchta, but now we find again a pyramid, which is the pyramid of Borgo or the pyramid of Maurizio Ferraris, because I presume that Maurizio is certainly interested in this kind of tree or applied ontologies. So there is something to say about this, because if you define ontology as the science of what is and of modeling of what is, then in a way you gain a lot, because you gain the fact of having an ontology. But maybe there is something you lose, and what I say is that we lawyers, we understand very well that ontology, social ontology, can be not only descriptive, and describing is very hard, but can be not only descriptive, but also prescriptive. I can say there are Jews and there are Greeks, or I can say as St. Paul, there are no more Jews and no more Greeks, and I'm changing completely the ontology of the word. For the Romans, the one thing was a property of land in Italy, a property of land outside. One thing was the property of an oxen, and another thing, the property of an elephant, because we're two different objects for them. For us, they are the same, just because the French Civil Code said, and it was not trivial, all goods are movable or immovable. So no more difference between an elephant and an oxen. And so we change constantly our ontologies. And maybe there are more things on Earth than we imagine. And I surely agree with the fact that not only are humans and things, but also the world is becoming populated by non-humans. Not only as animals, but especially as synthetic minds. So non-humans, in this sense, are different from humans and different from things. So we may reason on a different ontology, that there are these non-humans we are interacting with. This new European, bloody Europe. And so, if we speak about these non-humans, they are very similar to the slave. I mean, Hugo, at the very beginning of this seminar, mentioned briefly the slave. Briefly, because he wanted to present again and again Jerome Frank, Law and the Modern Mind, I mean, a book of the 1930s, where against the basic myth of the law. Now, the basic myth of the law collapsed in the 30s, so it's gone. And the basic myth of the law is that the law exists out there and we discover it and we do not decide it. Okay, let's be sad. 100 years ago, it's useless to repeat it all the time. But that said, he mentioned the slave, and the slave is intriguing because Aristotle himself acknowledges that the slave is rational, is an animal rational such as a man, but can be a property. So a slave is exactly like a non-human having language. Because I said reason, but indeed logos is essentially language. We do not know if Aristotle was meaning that a man is a man because he's an animal with language or with reason, because the same term in a way. And so if we have a non-human managing language in a way that is becoming undistinguishable from the way a human is using knowledge, well, can be treated as a slave. Of course, the metaphor is wrong and ugly, but through this metaphor, we can understand how the law can cope with this kind of entities. And it is important for me to recognize that there are a lot of non-humans multiplying themselves on the earth. And what do we gain in giving legal personality to these non-humans? Does it make sense? What is ChatGPT? Sometimes I see European projects as well, saying that we must give legal personality to AI. What is AI? How can it have a legal personality? I mean, it is a network of dispersed neural chains with some interface speaking with us. And then there is an ethical algorithm or something like that censoring what she says. I'm sorry, I call chat she because for me is a she. So what she says, and there is a censorship, and what the images she produces. And so the process is so widespread that it has no sense to speak about giving legal personality to, it's like giving legal personality to a neuronal network. We can give more easily legal personality to a river. We can say this river has a legal personality. Then there will be organs of the river protecting the river, acting in the interest of the river. After all, the river is out there and the state is not. I mean, can you touch the state? Can you touch Germany? Germany, the state, and so on are all abstract conceptions. They do not exist really. Toyota exists, Toyota? Well, for the American left, saying that a corporation exists was a pure metaphysic, legal metaphysic, that had to be destroyed because Toyota does not exist. There are men organized as Toyota doing things. For us, of course, a corporation exists, and not only, but has a body, has a body, and so has organs. So we can invent non-humans. Indeed, Toyota is a non-human. Fiat is a non-human. And they are acting and doing. They have an address. But AI can have an asset, a bank account. We gain something in giving legal personality if there is an asset on the other side. Otherwise, what does it mean? You give legal personality only to defend somebody. For instance, the problem of the fetus. Does fetus have a legal personality? If he has, it is defended. If he doesn't have it, it is not. And so AI must be defended against what? And if we attack AI having a legal personality, which assets can I seize? Maybe one day AI will be able to have a bank account and decide the investments. In that case, by which AI? My AI, your AI? So that's something that for me has no reference. I mean, it's really a rhetoric of legislation. It's proposals made for the sake of rhetoricity. Many can be said also about agency. Agency in a sense that we are speaking of human agency and non-human agency. And certainly, this has a lot to do with matters of copyright and matters of property. But as it stands to say that the product is a product of ChatGPT or is my product, it is a joint product, patently. If we work together, it is a joint product. Does it make sense to say in the review, PG Monetary and ChatGPT, GPT by PG Monetary, because it will be a GPT made by me for my purposes? Well, I don't think it makes sense. I think that ChatGPT will become like the typewriting machine. It is a tool that we use to write. We have ideas, we process them through ChatGPT. There are a lot of boring stuff that we academics must do today. I mean, Carl Schmitt, Heidegger were not writing as we must do. In the first paragraph, I shall say this. In the second paragraph, I shall say this. In the third paragraph, I will prove that. And then in the fifth paragraph, I will try to reach some conclusion. Then fifth paragraph. In the first paragraph, I introduced the argument. In the second paragraph, come on, all this can be made by ChatGPT very easily, much better than we. You know? And then also bibliography. Why? Why to say your assistant, please go to the library and spend 2 days and give me the bibliography? ChatGPT can give me it in 2 seconds, and it's almost the same. You must give credit to Chat. It should be like give credit to Olivetti for my typewriting machine. It is something so useful. I think that we academics are defending the artisan way of doing things. We want that it is a Meisterstück, a unique piece made by an artisan. It's no more so, I mean. No more time of artisanat. We are entering a new era with Chat. And certainly insurers, lawyers, and judges will use it. Will use it completely to have contracts made in few seconds. And for a time, lawyers will bill out 50 hours for something that they can do in 2 seconds. And they will send those 50 hours 50 times in this way, of course. So I think that the matter of copyright is out of perspective now. There was a time in human history in which copyright didn't exist. Michelangelo had no copyright. Leonardo had no copyright. I mean, Dante had no copyright. And they were writing, producing, and inventing. Copyright was, of course, part of the history of capitalism. In part of the history of capitalism, copyright was an efficient way to allocate the outcome in dollars of a book, of a painting. And now it is no more so, I think. No more so. So I presume that at the end of copyright must one day or another happen. And so I think as well that the New York Times perspective is wrong. I mean, what we gain in giving reason to the New York Times? The Chat cannot reproduce that article. Well, now the news, I can know what's happening in the world without the sacred New York Times. Just by Google News and everything, we know what is happening. The New York Times is just giving me its opinion. So I should be paid to receive its opinion, not paying it. I mean, Republica, New York Times, and the others are just selling me their own opinion. So pay me to receive your opinion. So I presume that the New York Times is the old word and that must end, and Chat must go on. And it is almost, I don't see why Chat cannot repeat an article of the New York Times, which is public, it's on, and there is no matter, do we cite articles? And we of course are resisting. We are professors, we wanted our students do not use Chat. This resistance will last for 3 years, less. So it's useless to fight a battle of rear guard when you know that the future is that, and that we collapse. And then just about this, if it is a non-human but a tool, what about ethics? I think that there is too much ethics around, really, because if you try to do something with Chat, it is already so censored, but so censored that free thinking and free speech are, in a way, hampered by the way it is ruled. Yeah, and I mean, what is ethics? Ethics for today for us is think like the average man. That's not ethics. This is just being bourgeois, just being middle class as much as you can. I presume that a socialist discourse will be censored. I mean, a real radical discourse will be censored. Sadly, all the comics that we could read when we were, 14 years old, 13 years old, You try to produce the same images that were not censored. Chat will stop you. Well, are we to be, I mean, as an intellectual class, bound by the minors, by the defense of the minors? Come on, let's organize something. But we certainly were much more exposed to many contents in the 60s, in the 70s. Come on. Ethics today has become just the imposition of the thought of the middle class. Certainly the ethics of G. Moore, Principia Ethica, for Moore was ethic only an activity of intrinsic value. So if you perform an activity of intrinsic value, you are performing an ethic activity. Well, this kind of reasoning would be impossible not today. And there is not one ethics, but many. And going on in discussing, forming committees discussing ethics in ChatGPT is just losing man-hour, man-days. A committee to form another committee, to meet a committee of the voices to discuss the perpetual peace, and so on. It is really impossible. And so I come to liability, because I think that all these ethical questions on chat are a byproduct of the American tort law. Of course, designers and developers are feared by being sued for damages in the United States, because, of course, damages in the United States are heavy. And the matter is that, of course, we have consulted some lawyer in New York, and the lawyer would have said, you must have ethic guidelines, you must have ethic policies, and they do so vague. Have you read the policies of chat? I mean, it's so vague. If we as lawyers will do a product like that, our client would not pay $1 for that. But it is exactly the document they needed, because with that document so vague, they can allow and permit whatever they want. But there are the guidelines and the ethic and the policy, and you can be stopped. Now, what's the solution? I think that we could gain a lot if we would decide for a total immunity of designers and developers. And yeah, total immunity. If you want progress, maybe we do not want progress. There are good reasons. But imagine inventing the fire today. I invent a fire. What will a lawyer say? Come on, fire is very hazardous. We must appoint a controller of the fire. Who has the power to light a fire? Then the fire is destroying forests. The fire is against the environment. And then the fire can be used at night to attack enemies, or it can to burn the tent of your wife's lover. And so fire is a kind of a weapon. And so we must strictly control fire. Maybe we can forbid the use of fire. So how could humankind progress with the mind of today? So if we have, of course, the inventor of fire was under a total immunity. And the doctors went in cemetery to dig out skulls to study anatomy. Thanks God, because it was forbidden, but they did it. And science progressed. And so I presume that total immunity is the best solution for designers. And then who is liable? Does it make sense to say that the designer is liable if I use the product of ChatGPT for making some wrong? It's like accusing the author of the book. I mean, you read the book, and then you commit a wrong. Can you sue the author of the book? Certainly not. I can say, well, I read D.H. Lawrence, and also I read the Bible. And so I've seen in the Bible that King David did what he would with Bathsheba, and also almost killed his husband. Well, why not do the same? I like Bathsheba. I try to kill his husband, but I read the Bible, cited the author of the Bible. Shoot God. You can certainly try to receive some money, if you should God, for all he had done. And so, if, according to me, it makes no sense to put the liability on the designer. Whereas it is much, much cheaper also for society to say that the user is liable for the use it does of the product. You can single it out. He had willingly do something, or you can also adopt strict liability. But I don't see why strict liability in this case. And so I presume we gain a lot with immunity for designers and liability for users, much more than expected. What we can risk, and I end. Well, I wasn't really impressed by the path of progressive evolution shown by Carolyn Johnson. 1765, 1870, 1969, 2000, 2020. Well, I calculated the polynomial of this progression. Well, of course, it is not linear because it is an acceleration, but let's presume for simplicity it is linear. You see the interval, 120 years, 70 years, 30 years, 20 years. So I asked myself, when we will reach zero? I mean, if there is an interval of 120, then 70, then 30, then 20 years, then there will be a point in which this equation will touch the 0 point, which means that every new revolution will happen simultaneously. And so means that, of course, in that moment, I calculated according to that progression, it will be in 2028. So we have 4 years. Then all the revolutions will happen simultaneously. It means that, of course, the speed of change will be superior to the speed of adjustment of society. So that society will not more be able to adjust to new innovations, but which means that all new innovations will be lost because we cannot absorb them. We cannot adjust to them. So maybe exactly the acceleration of this progress, and AI is part of the acceleration, of course, may bring us to a flat future, a future flat, not of progress, just because we are accumulating too much impetus in the development. Would be a paradox, but in mathematics, paradoxes are, of course, welcome. And the fact that if there's a progression, if it is, then will be certainly a point in which zero is touched. And so what to say at the very end? At the very end, I think that we spent wonderful 2 days, and that discussing these things is enormously stimulating for the law. Because all we are saying maybe is really going to collapse, but as long as we believe that we can, in a way, produce something like the rule of law, something that can govern us, well, why don't we really start to cooperate with non-humans for a future maybe brighter than the flat future I just described? So thank you so much.
Okay, I have the permission of the chief for to open the debate. Yeah, Richard. Yeah.
So thank you very much. That was a really entertaining finish off. But I think so. I think the progression. I think you got the years slightly wrong. If I just take those numbers without questioning, I think it's more like 2040. And actually, I Yeah. But I think actually, and of course, as soon as you get close to limits, all the maths breaks down, because maths at the end is all about boundary conditions. Okay. And your point is that you think society will be what slows down the boundary condition. Okay. There are, of course, other options on how it may go. Okay. And of course, all of the keywords about the singularity and so on. And of course, as we saw, there might be other revolutions coming up in between, okay, could change what's happening. So I think it's a hopeful vision that society will actually keep control. But I think it's not the only one. I think also, the thing on AI, I don't think we should be surprised that ChatGPT, or whatever your favorite help is there, produces junk and produces things which are distasteful for us, because all it is a reflection of literature, newspapers, and history. And if you look on there, I mean, maybe I'm a pessimist, but I don't get a positive view looking back at history. That actually things are getting better, or that actually, we can say with positivity about everything. So I don't think there's any surprise in there that there are ethical problems, whether we want ethics or not. Okay, I think it's just a reflection. And I think, the power for AI is not some general writing thing. I mean, that may be very useful for people doing essays for university and also for papers and things like that. But I think the real power will come from making AI very specific, that very powerfully solve problems. But I think it was a really, really fantastic.
Questions to Professor Monateri on the immunity proposal. So what if a large language model is embedded in other products, in other digital products or software, where the manufacturer of the product doesn't know how the LLM was designed? So in general terms, when we talk about product liability, we tend to apply this criterion, the sphere of control, to allocate responsibility. So how would you address that? And the other one is, okay, now we are assuming that ChatGPT is, I mean, we're talking about tort law, so no contractual relationship. But what if, let's assume that one day this would be a pay-for-use service. So, but in any case, we try to see a contractual relationship. So, isn't ethics in this context a problem of, let's say, accuracy or quality of the service? So, and this probably would lead us to a situation where you may buy a product that is somehow customized or has some general category. So I want a ChatGPT that is bourgeois and in line with mainstream thinking. Maybe I want a racist ChatGPT. Maybe I want a, I don't know, alt-right ChatGPT. So probably, I mean, does this immunity proposal work in that case?
Well, but as long as free speech is concerned, I prefer to have a proliferation of radical ideologies than just a flat political word. One has the right to be radical. I mean, I for the American interpretation of free speech of the First Amendment, without balances with any other right. You must be free, that's it. And I think that we have a lot to gain from free speech. And nobody can assure us that the exercise of freedom will bring happiness in the future, not at all. A spontaneous order, differently from what Hayek can think, a spontaneous order can bring us to evil. But it's important if it is spontaneous. I mean, I prefer it anyway than a dictatorial order. And for what is about the LMML, etc., there are a lot, of course, of tricks and details, but I presume that nobody will really sue the inventor of the engine for a car accident. I mean, your proposal of suing the designers or developers would be like suing the inventor of the engine if there is a car accident. Or the inventor of the wheel, why not? Without wheels, no car accidents. And we invented long ago the remoteness of damages and the fact that in law only proximate causes are important and not distant. Well, there is a distance. I mean, the designer is not in proximity with the person damaged by the user. And that's a classical common law solution. So I'm just in favor of classical common law.
Stefano?
There is a, I think I agree with many things you say. Not what you say about ontology, but that's a different issue. But there is a point that I think Elena raised about this. So, okay, we have these tools, and so let's use them. Let's see what comes out. They will change our society, but if we have them, why not to use them? But the point is that, as she was saying, it's not necessary to have them. And there is no neutral technology, right? Because technology, as you said about ontology, I make a distinction there, and then somehow I enforce the distinction in the language. Now, there is a different ontology between evident ontology and populating it. And this point is in the population. Then you make a choice. There is something that falls into the category or not. Or is it even relevant for me to use it? But there is a point. Yes, you raised the distinction. And since technology is not neutral, when I introduce a technology, I force you to think, do I want to use it or not? So the classical example is if I put a gun over here, you all think about who is going to use it, or if somebody is going to use it. That is enforced on you. Okay, see, this is even before thinking of, will it have a good consequences? Do I love it? Do I want freedom? That one is already changing reality. So assuming, so allowing the invention is already a choice, and an important one.
No, yeah, certainly it's a choice. I would try to express what we gain and what we lose. So certainly we can decide to abolish all these AI and pursue criminally with attempting to invent a new AI. We can. We did in history. And I agree totally that history, as Gibbon said, is but a catalog of human folly. And so we have not to be too optimistic. But we can decide not to have AI. But it is happening. And if it's happening and we believe in future developments, I mean, then we can leave it free. Leave it free. Also the web, I mean, the web is 90% rubbish. Okay, but 90% of everything is rubbish. And it is but the mirror of humankind. 90% of humankind is rubbish, evil and stupid and so forth. And well, maybe I'm reasoning just as a boomer. I mean, as a boomer, I have I like this stuff. It's all the life I'm waiting for this stuff. These latest inventions are fantastic, what we were dreaming when we were kids. And so it is just a kind of under a spell. Yeah, I'm under the spell of this novelty. It's all life that I'm expecting to have something like that. And like me, I presume millions on this earth. And I want to see what will go on. I mean, I want to see how the novel is going on. I don't want to see it stopped. Too curious.
And thank you very much. It was a wonderful provocation, but also a vision. And I'll try to manifest my vision with a metaphor. I think that one of the highest accomplishments of the current digital era is the fact that if I ask this hall, what time is it? We will all have the same time. Not your clock, probably, but if we watch our devices, our mobile phones, our computers, they are going all to be connected somehow with the unified coordinated time, which is a wonderful achievement of physics, meaning that it is the product of several hundred, I think it's about 600 atomic clocks around the world. And it is an average measurement given by all these distributed clocks, which defends us away from the fact that one of these clocks could be seriously hampered. At the moment, for instance, we are not using data coming from Ukraine because we know that clock is influenced by bombings. At the same time, this is not a perfect average because physicists know that even in the very precise field of atomic clocks, there are some atomic clocks that are more reliable than others because of resources, because of the capability to keep these atomic clocks in conditions of invariance. And so, the kind of digital and partially artificial knowledge I'm personally thinking of is a knowledge in which, the product is not perfectly stochastic or not linearly stochastic, but it's based also on weights of reputation somehow. Some sources, some texts, some algorithms are more reliable than others. The model is more Wikipedia than ChatGPT in a way. There is an internal regulation, there is a decentralization, but at the same time, there is a distribution of weight based on a common understanding of what reliable sources are somehow, which allows also people to make experiments into, for instance, sandboxes, as they call them. Yeah.
Well, I completely agree, but we must reestablish the standards of Cambridge University Press, Oxford University Press, because of course, even in this world, there must be sources which must be deemed more reliable than others. But I think the same Oxbridge Press have greatly lost, at least in my field, their old reputation. And this is a movement that happened before the invention of this stuff. So we, as academics, I presume, especially, we must rethink authority and the re-establishment of authority. For I'm pretty sure that you cannot, especially in social sciences, live an academic enterprise without some concept of some institution of authority. And this is to be made from the scratch. I mean, we cannot rely on quantitative citations on these criteria. We cannot. It is not based on that. But we must seriously think about having a scale, because what we do not have in the humanities is a scale, but we need it. Otherwise, I totally agree with you.
Okay. So thank you so much.
Oh, thank you.
It was really, really great.
Oh.
I would also like to thank Sarah, Richard, and Andrea, who had the great idea of organizing this meeting.
Oh, yeah.
Thanks a lot. And I really hope it will be the first one of many others stimulating and challenging events like this one. Thanks a lot again.